here. And myself very glad to be here. To talk about business ethics, compliance, corporate social responsibility. So I don't know if you're familiar with this topic, but we thought it would be a good topic to talk with you today because with globalization, it's more and more important for corporations to comply with social and environmental norms all over the world. Not only it comes basically from the US, where our main corporations biggest corporations are located, and as parent company have subsidiaries all over the world, it's getting more and more important to be aware of international standards in environmental and social standards, which applies mostly everywhere. And I guess in Russia you also have, I have to confess I have no knowledge of Russian law, but I guess it's getting also more and more important here, and especially because Russian companies also have subsidiaries in Europe and probably in Asia. And these norms are today very important for executives to know and to prevent all kind of risk, including like reputational and financial risk related to the violation of environmental and social standards.
If you let me just add something. As I understood, I am a young lawyer, or I hope so, and you are also young lawyers. And to say it straightforward, compliance is the future. So you will have to deal with it at one point or the other one. That's all I had to say before you start your compliance business ethics.
So we're going to talk like together because I'm doing, so I didn't really introduce myself, but I'm an associate at Jones Day. So this is an American law firm, but they have an office here in Moscow, and I'm part of the environmental health and safety practice. So we're doing sites remediation, products liability, all these kind of things. So I'm going to talk about environmental and social standards, environmental and social governance, but Ralph is going to talk about corruption and violation of human rights. So as the legal framework is quite the same, we are interacting with each other, and I ask you to interrupt whenever you want to ask questions, or if you want some clarification, please do not hesitate and step in. So I'm going to start my presentation by briefly explaining what is corporate social responsibility. So I don't know if you've heard of it before. It's not something that is, it's not a traditional class that you can have in law school. When I was in law school, it was not the kind of class you'd have. But it's, as Ralph said, it's getting more and more important. And at the time I was at school, not a long time ago, there was no, corporate social responsibility was not even law. It was more how to behave in a good way for corporation, how to endeavor the social dimension of corporation. Because corporations have a role in a society, and it's always better to have a good behavior for your companies, mostly for your reputation. But there was nothing compulsory in corporate social responsibility. So it's basically act in a sustainable way. So integrating an environmental and social dimension in a business context. So Milton Friedman said that the only purpose of corporation is to make profits. So that's right, and we all agree with that. But the thing is, today, in a globalized world, it's getting more and more complicated to do business without integrating, taking into account the environmental and social impacts of your activities. And this can be traced back to the concept of sustainable development, the Brundtland Report in 1987, the Rio Summit in 1992, and more recently the Sustainable Development Goals in 2015. So this is sustainable development is more like a global concept which push actors to integrate this environmental and social dimension, respect for human rights, in a business context, in the economy. And from the beginning, it emphasized the role of non-state actors in achieving sustainability. It's not that common, because we all know that law is made by the parliament, the executive, but not by non-state actors, but not by associations, not by individuals, corporation. They are not associated in the process, in the lawmaking process. And this is corporate social responsibility as everything to do with including the participation of non-state actors and make them include them in the lawmaking process. So, and more recently, over the last few decades, there have been massive human rights abuses, financial scandals, environmental disruption related to the activity of major corporations, oil and gas company, Total, Exxon, and a lot of companies, a lot human rights abuses, for example, in Africa, financial scandals in the US, environmental disruptions everywhere. I will get back to this very famous case in France, the Erika case, with when a oil transporter just oil spill, yeah, exactly, thanks. And so corporations have been aware that they need to prevent the risk induced by their activities, to take this risk into account and to anticipate this risk. So they put in place standards, code of conduct, code of ethics, whatever the name, but nothing compulsory, just in their own management process, business process, but nothing compulsory. So this is the thing I want you to understand. This is when corporate social responsibility is at first something voluntary, not compulsory. This is really for the company, it's for their reputation. Just they look good and so that they can do business. And so so you have like top-down regulations, what we call top-down regulation, traditional form of regulation, which means that like the states or the authorities, parliament, the executive, just impose norms, legal norms, on social actors, and what we call now the bottom-up approach, meaning like corporation, individuals, associations are also creating norms that will bind them, and this is a more open process of lawmaking, and this is more and more relevant at on the international stage, but it's also on a national level, and especially in France, but I think it's also the same in Russia. We're seeing the same phenomenon all over the world, where non-state actors are stepping in and are involved in the lawmaking process. So the second key word here is compliance. So compliance is more used term even in law schools. It's just complying with laws and regulation. So basically, corporation needs to be aware of the current state of the law, and that's why they have in-house counsel, or they just have lawyers to defend them. As you can see, compliance is more about complying with enforceable, binding standards, what we call hard law, whereas the corporate social responsibility is traditionally made of non-binding standards to prevent reputational risk and provide incentives for actors to act in a more sustainable way. But the things are changing. The fact is, so we're taking the French example, but in France, the corporate social responsibility was mainly voluntary, so complying with voluntary international standards. But now it has been integrated into the legislation, and courts are taking into account also the corporate social responsibility. So both are now converging. And that's why we put these two concepts together. It's because corporate social responsibility and compliance are converging, and we don't know what is the proper term now, so we choose just to present a brief, to have an historical perspective on this topic. Do you have something to add?
No, just if you want to change.
Oh, right. So the first step in regarding compliance in French law was the European Union Green Paper on Corporate Social Responsibility. So you have a good definition that is on the slide. So being socially responsible means not only fulfilling legal expectation, but also going beyond compliance and investing more into human capitals, the environment, and the relation with stakeholders. So stakeholders is a name that you give on the international stage to typically non-state actors that are not allowed to make. So when you're concluding a treaty, for example, states are concluding treaties, the federal state of Russia, but not local communities, not, of course, individuals or associations. But on the international stage, they're, especially with regards to environment, they're associated with the lawmaking process. And this is where compliance and corporate social responsibility are converging with like the association of non-state actors. The first law on corporate social responsibility and compliance regarding French for France was in 2001. So the idea comes from the US. This is a report and comply, or report or explain. So meaning you have to disclose your sustainability performances, or you have to explain why you don't. So, and of course, if you don't, it makes you very suspicious. But at first, it was like corporate social responsibility, no obligation. It was voluntary. You do it. It's fine for your company. You don't, there is no sanctions associated with the fact of non-reporting on your business activities. No, it's an obligation. This is hard law. You have to report on your activities. At least when you're, so in 2001, it was only for listed companies. In their management report, they have to disclose information on the social and environmental impacts of their activities. So it was just for the most important companies in France. And then we had the Grenelle II law of July 12, 2010, which expands the CSR reporting obligation to every company with more than 500 employees. So it's a lot of companies in France. So it just excludes small businesses. And the obligation, there was also an obligation for corporation to for their report to be verified by an independent third party. So to make things more homogeneous and try to have more visibility on the process. And as I wrote, sometimes the reliability of information is uncertain because, of course, the corporations are evaluating their own activities. So sometimes you have information which are not reliable, and it's very hard to control what if the information are reliable, and to compare information from a company to another, because they may present the things very differently. So what most corporations do in France, they use voluntary standards, so not compulsory standards. You don't have to comply with these standards, but they help you to draft this management report. So the main one is the Global Reporting Initiative, so they provide a sample of management report that corporation may follow. How does it impact us as lawyers? It's like we also have to be very careful when we are advising corporations on even M&A deals. I mean, as environmental lawyers, I'm not doing a lot of M&A, but sometimes our M&A team is coming and asking for drafting some clauses relating to the environment, and more you have to think about compliance and corporate social responsibility, asking if the corporation is aware of this regulation, know that he has to report on these environmental and social obligations, something we M&A lawyers are not used to do. But it's very important to be aware that I know that for Jones Day it's quite obvious because they are like a very large practice, so they have environmental M&A. But for small law firm, it's not that obvious, and you don't think necessarily to environmental and social question issues. So this is also something you have to be aware of if you're doing transnational if you have like transnational activities. And finally, we have like the ordinance of July 2017, which is a transposition of the directive of 2014 on the disclosure of non-financial information. That's how we call this obligation in France, non-financial information. And so this is for a large number of companies. This is listed companies with 500 employees and a 40 million euros turnover, or 20 million consolidated turnover, and 100 million turnover for non-listed companies. So it's this obligation is also expanding. And we think that about 90% of the corporation are now businesses, excluding small businesses, but businesses and corporations are must report on their environmental and social obligations. And this is where you step in, I think. Okay.
This I think will be my part mainly, but maybe I'll talk later about it. Or
your presentation will be there.
Okay, so that's my presentation. So first, maybe we're waiting a bit, but let me introduce myself. I'm Ralph Moughanie. I'm working in a law firm called Boken, which activities is mainly litigation, white-collar crimes. Maybe 70–80% of our activities is about litigation. And we have a lot of complex litigations with both commercial and criminal aspects, and both national and transnational aspects. So the presentation came just here, and let me start. So I'm gonna talk about this French recent compliance law, and Pierre did a very good introduction for this law. It's a revolution in France. It's a revolution in France, and maybe it will be a revolution in other countries. Most of the companies are already using this compliance method, but it's soft law. Here, it's hard law. It's going to be mandatory for all kind of company, and we'll come back on this later on. So what is it about? This law is called Loi Sapin. Sapin was the minister who took it and who actually adopted it, or who wrote it. It was enacted on December 9, 2016, so it's quite recent. And all the decrees are still ongoing. So what is this law? I'm sorry for the translator, but I'm going to talk a bit French, but I will translate it in English. So it's loi relative à la transparence, à la lutte contre la corruption, à la modernisation de la vie économique. So what is it about? It's about transparency and prevention. Like Pierre said, it's very important for companies because they are given credibility. Let's take a simple example. You're a big company, you want a loan. The bank most probably will require the company to give their own procedures because they will have this obligation to check if you're not money laundering, etc., etc. So this will be a very important commercial business, if you want. So it has a real economic value and a legal value. I'm gonna stand only for the legal value. So what is it about? Let's just translate the name of the law. So, loi relative à la transparence, it's quite obvious. It's law related to transparency, à la lutte contre la corruption, which is the fight against corruption, and the modernization and la modernisation de la vie économique, which is modernization of the economic activities. So what is really at stake here, it's this law concern probity offenses, which is lobbying, conflict of interest, whistleblowing, corruption, undue influence. Obviously, we will not talk about all these provisions. It would be too long and not really necessary. So I will mainly focus on the program that has to be implemented in all kind of company and its impact on litigation. So first, why did we adopt this law? Well, in France, we had a lot of cases where basically, but it was legal at the time, we were corrupting foreign officials, and that was not really, how to say it, that was not well seen by most of the country. It's a convention in 2002 that stopped this, let's say, how can I say this? That stopped this
practices.
Yeah, this practice, we can say it like this, in 2002. But before that, it was allowed to corrupt people abroad, not in France, but abroad. So we had this report of Jean-Louis Nadal in 2014, who basically stated that French companies were, and I think they are not sufficiently concerned about the fight against corruption. That was one of the first steps that compelled the minister or the ministry to adopt this law. There are other elements that made us adopt this law. You have the French ranking in Transparency International, which is insufficient. We were like 26th on almost 200 in 2014, and 23rd on 2015. We had also a lot of critics in France and abroad about the French compliance. They deemed that we didn't have enough means to fight against corruption and undue influence. And the last argument maybe, and I think that's one of the most important, is the US and the UK primacy, which is the FCPA and the UK Bribery Act. Mostly, but I will come back on this, French national companies were sued and basically taxed and fined in those countries, and sometimes it was heavily fined, or these companies were heavily fined, but we'll come back on this. So, oh, that's here. So I'm going to talk about two things mainly. The first one is this obligation of implementing this compliance program, preventing probity offenses, which is mainly corruption and undue influence. And then I will talk about this French extraterritoriality, which is new, and it will be like in the US and in the UK, and the French DPA, which is a deferred prosecution agreement, which is basically an agreement between the state attorney and the company who's charged to finally pay a fine and not being prosecuted. So let's talk about this compliance program, preventing probity offenses. So what is it about? It's Article 8 of this law. The obligation of detecting and preventing in France and abroad corruption and undue influence. Let's take this phrase and check it out. So the obligation, so this is mandatory. You have no choice of detecting and preventing. So it's before any litigation cases in France and abroad. So it's mandatory for French company, but also for French company with subsidiaries abroad. And if you see it the other way, it will be for foreign company with a subsidiary in France. So you have to keep this in mind. As a lawyer, if you have a client who's working in France, whose activities are in France, you will have to tell them, if it's a big company, but we'll come back on this, you will have to tell them that I have to implement this program. So, to prevent corruption and undue influence. What is corruption? I think most of you know it. It's to compensate or offer any advantages to a decision maker. So, to compensate, it can be money, it can be a present, it can be anything. It has to be an advantage. That's all you have to keep in mind. Or offer, so you don't even need to pay it. You just have to tell him that you're going to pay him. So it's a very large definition. Any advantages, I told you, it can be money, it can be present, it can be any advantages to a decision maker. Who is a decision maker? He can be public, it can be a state, it can be an agency, but it can also be another company. This is public and private corruption. Corruption can be also active and passive, whether you are proposing or whether you are receiving the bribe. What is undue influence? Undue influence is basically the same, but you're using an intermediary to do the, let's say it like this, the dirty job. You are going to pay someone that is going to influence the decision maker. So here, let's point something which is not very easy to distinguish. It's very difficult to distinguish the undue influence with lobbying. Lobbying is legal, undue influence is not. So what is the main difference here is maybe in lobbying, you are not paying. You are not paying, you are not giving any advantages. It's a very slight difference. I think it will have a lot of complication and a lot of litigation will rise from this difficulty. But however, this obligation of preventing corruption and undue influence is materialized in 7 main provisions. I'm going to talk only of these 7 main provisions. I'm not going to talk about the additional recommendation of the French agency in charge of fighting corruption, because otherwise it will be a bit too long. So what is it about? The 7 provisions to prevent corruption. The first one is you have to adopt, or the company have to adopt, a code of conduct describing the prohibited behaviors. That is very clear. Like, let's give an example, even a stupid example. You have to write down that, for example, it's forbidden to pay someone an amount of money to have a contract. It's very stupid, but you have to write it down. It's logical, but you have to write it down. The second provision is the internal alert reporting procedures. You have to write a procedure, an internal one, naming an officer, like you have in financial institution, you have the compliance officer. Here you have to name also, or appoint, an officer who will be in charge to receive all the complaints or any report. Then you have the risk mapping, or the risk assessment. You have to set up this risk for, like, in a way where you will have, for example, a risk in this country. You will have a risk for that kind of companies, for example, using an offshore company or bank account. You will have to point that risk out. Then you have the procedure to evaluate the risk on the most important clients, providers, intermediaries, and partners. This is very common also in financial institutions. It's different from the third provision in that way that to evaluate that risk, you will have to evaluate one specific partner or client. What does it mean? You're a bank, you have a huge company asking for a loan. You will have to practically make a paper with the name of the company, write down what you checked about this company online, whatever, on some database, like, what's the name of this database? It's a check, I don't remember, whatever. You will have to check, like, practically who this client is. Then you have the 5th provision, which is internal and external account control. That's very common. Usually the accountants are doing it. You can have Ernst & Young or whatever, like the Big Four. Then you will have the 6th provision, which is the formation for executive and exposed employees. That's also very common in financial institutions. And finally, you will have the implementation of internal disciplinary sanctions. That is also very common. It's clear enough. So let's continue. Who is concerned? So it's a large definition. In France, it's more or less 1,500 groups who are concerned. It's groups with more than 500 employees and 100 million of turnover. In that case, the subsidiaries will also need to implement the program. Then you have a second kind of group who is concerned about this program. It's the companies who are establishing consolidated or common accounts. I don't know if this is clear, but in France, a consolidated company is a group whose every end of the year or every fiscal year or tax year will issue the account of all the group. In that case, not only the subsidiary will have to implement this program, but also the controlled company. What is a controlled company? Well, you don't have a clear answer. A controlled company, basically it's 50% of the company. If you holding 50% of the shares of the company, you have the control, 50% plus one share. But like if you're a huge company and you're holding 25% of a huge company and all the other shareholders are small shareholders, you have the control of the company. So it's a case-by-case method. Who are also concerned? The executive officer, the member of the boards, and this is very important because they will be held responsible for this program or for the absence of this program or the insufficiencies of this program. So in France, most of the major groups, and even in the world, have already implemented similar recommendations. So it's not very new for them. You can have like the French Total, but you'll talk about them later. They already have that kind of program, so it's not very new for them. It's maybe harder for other companies, smaller companies, but they are still very big companies. So what are the sanctions? The first sanction is the administrative sanction. This will be, or this sanction will be like adopted, or let's say it another way, the agency in charge of fighting corruption and undue influence, which is also a creation of this law, will determine the administrative sanction. The procedure is step by step. It goes to a formal notice to the sanction. The sanctions are adopted by the commission of this agency, and the administrative courts have final jurisdiction to state on this sanction. So, what is the amount of this sanction? It can go to 200,000 euro to 1 million euro. It's not a fine, it's an administrative sanction, or it's an administrative fine, it's not a criminal fine. What about the criminal sanction? Well, there is no real specific criminal offenses if the person subject to this obligation do not comply. So how, okay, I'm saying there is no criminal offenses, so why am I talking about this since mostly we're doing litigation and criminal litigation? Well, because you have criminal implication. You have a new article of the criminal code, in the French criminal code, that basically states that the company who was condemned for corruption or undue influence can be monitored by the agency to implement this program, and all the fees and expenses will be paid by the company. So you will tell me this is not like a real big sanction, and you're right, it's not a big sanction. It can cost money, but it's not a real criminal sanction. But what is the most important is that if you don't have this program implemented, you will, or the judge, we don't have the cases. I mean, we don't have case law yet about this specific program, but you have high probabilities that the judge would presume that you had the intent to do, or to corrupt, or to corrupt. Why am I saying this? For a simple reason. As you all know, I think it's the same in Russia. For a criminal matter, you have two prongs. You have first to act. So you have the material act, which is the fact to corrupt, but you also need to intend this corruption. And this is a major point. Like, if you're the company, the only fact, or there are high probabilities that the only fact that you won't have this program will be enough to show that you intended to corrupt. We will see later, I mean, in the future, if the judges and the case law will have this approach, but there are high probabilities. So would be enough to show that the natural person leading the company had intent. It's maybe more difficult for natural persons, but for the company itself, it's going, I think, to be automatic. The company and the group also. So let's talk maybe later.
Yeah,
maybe later you go back. Okay. So I'm giving back the parole to me.
Your presentation, you need again. Yeah. 30 seconds.
And this is where so environmental and social obligations and corruptions are also converging. We had a new law in France in this year, in 2017, which follow up on a disaster that happened in Bangladesh. This is the Rana Plaza case, where in Bangladesh there was a manufacturer that just crumbled, and there were thousands of Bangladeshis were killed, and they were obviously working in terrible conditions, and many French companies were using this Bangladesh company as a provider. But at the time, nobody was caring about the working conditions of these people, and that's why now. So of course, it was ethically, it was something that should not happen. But it was still, there was no obligation under French law to take care of these kind of things. It can damage your reputation as a company, but you don't have any obligation. You didn't have any obligation related to the monitoring of the production process, production chain. It changed in 2017, so now companies must ensure that the production chain, so your subcontractors, your company, your subcontractors, your suppliers, and your lawyers, you have to check everything. Comply with social and environmental standards. And this is I talked about stakeholders earlier, so this is how it works. This is not state authorities that are going to check if everything is fine. This is the duty of the corporation, of the company. You are, in a sense, you are your own enforcement authorities. You have to make sure that the company is doing everything it can to respect social and environmental standards and fight against corruption when it deals with its subcontractors or suppliers. So this is an obligation for some companies, not all companies, but which employ over 2 consecutive years at least 5,000 employees, or a total of 10,000 employees, which include subsidiaries, to draw up and implement a vigilance plan. So what is a vigilance plan? It's just you have to identify as an executive of a company the risk, environmental and social risk, and prevent serious human rights and human rights abuses. So you have to, in this vigilance plan, you have to include risk assessments, draft a report on the reliability of your subsidiaries, check that everything is fine, that they are respecting basic environmental and social standards. You need to take action to mitigate the risk. Be sure that nothing will happen while you're dealing with these companies. And take monitoring measures, early warning, the alert process, and of course disclose this plan. So if something happens, you can just say to the authorities, because it's also, Ralph is doing litigation, but together we're also doing a lot of transactional. And when you're representing your clients in a meeting room like that, and you have like 10 officials like saying you did it wrong, you have like this vigilance plan saying, look, we did all that. We were complying with regulation, all the regulations. We put in place this vigilance plan, and as you can see, this is very exhaustive. We did our best to avoid any kind of problems. It happened, but we did our best. We are virtuous. And this is a basic argument, because you don't have a lot of arguments, except that the saying, you comply with the law and you did your best to avoid that. That's what happened. And of course, the vigilance plan can refer to the non-financial report, the reporting obligation we talked about earlier, because it's the duty of vigilance and the obligation to report are closely related. And I think you talk about, so maybe we can talk about this together, the litigation risk. So criminal liability, we talk about it, but when it comes also to parent companies, it's very important to be sure to avoid this kind of risk for your clients, because what they fear is being criminal like prosecution and being criminally responsible, liable for what they did. And the Erika case is very interesting. I think this, the Erika case is very interesting because it was like Total was using, so it was, Total is a major group and they have some subsidiaries, and the owner of the oil tanker was a Panamanian company, Total subsidiaries, but no employees, nothing. It was just a company in Panama. And Total was found guilty, the company, the main company, so the parent company, was found guilty of pollution offense. So there was like oil spills on the French coast. And the company was in compliance with international maritime law. They did nothing wrong on this side. It was perfectly fine. They respect all the standards. The boat was like 24 years old, but you can keep the boat going for 25 years, so it was fine. But the court concluded that Total was negligent in its vetting procedures. So this is a monitoring procedure for this kind of oil tankers. But this vetting procedure was not imposed by any laws. It was just an internal procedure that Total put in place on its own initiative. And for the court, for the Cour de Cassation and the Supreme Court and the Court of Appeal of Paris, it was enough to qualify as breach of its ethical and corporate commitments. So it was enough to qualify as a pollution offense. Because Total was in breach of standard, even if it was not a law, even if it was not legally binding, it was something that Total put in place on a voluntary basis. And so it was found guilty of that offense, even though there was no breach of any hard obligations. So this is why this case is very interesting, and and companies have to be very, very careful when they're taking commitments, even non-binding commitments. And of course, but I think we can, I'm not going to talk about this for long. You have also the civil liability you have to take into consideration. Because, for example, the law on establishing the vigilance plan expressly specify that you can be liable if you fail to comply with your own vigilance plan. So, and as you can see, you can have a 10 million euros penalty, which is quite huge. So to be sure to have to have done everything you have to, and this is something that as lawyers we have to also to check that the vigilance plan correspond to comply with all the provisions of the law.
Maybe we...
Questions? Yeah?
No, I don't know if anyone has a question for Pierre, but...
Да, вопросы задавайте, друзья, пожалуйста, будьте добры. Пожалуйста, девушка, да.
Здравствуйте, меня зовут Фомина Анна, я юрист команды 29, это правозащитное объединение журналистов и юристов из Санкт-Петербурга. И вы сказали, что небольшие компании не могут нанести такой существенный вред экологии и существенный вред окружающей среде и людям, которые находятся в реале деятельности данной компании. Но я хочу вас погрузить немного в российскую реальность. У нас есть такой регион, как Кемеровская область, угледобывающий регион. И вот как раз-таки в этом регионе распространена практика, когда угольные разрезы разрабатываются именно маленькими компаниями, у которых основной капитал минимальный, возможный для России в размере 10 тысяч, и они не несут никакой ни социальной, ни экологической ответственности. Вот я бы хотела узнать, во Франции есть ли меры воздействия общественности на подобные случаи? Слышит ли правительство голос народа, когда приходит компания и говорит, что мы хотим здесь разрабатывать уголь или другое полезное ископаемое, но для этого надо изъять земли у людей, которые живут здесь много лет и которые не хотят расставаться с этим местом. В России это не так. В России народ не услышан, и люди вынуждены жить, дыша пылью угольной, и при этом в Кемеровской области такая ситуация, когда множество разрезов начали разрабатывать, получили сиюминутную прибыль, и все, и они уходят. А люди окружаются вот этими угольными разрезами, и ситуация только ухудшается.
Yes, yes, associations can do something, and this is something common in the field of human rights, corruption, and the environment. All stakeholders are also involved, and in particular association, they have specific rights in litigation in France. And on environmental matters, the prosecution can be engaged by associations, for example, especially on environmental matters. When environmental damages are occurred, there was like a new law very recently on the préjudice ecological damage. So associations have a very specific role when it comes to the environment. It is related to, I don't think that Russia is party to the High Risk Convention on well, on the participation of the civil society in environmental decision making. But it's not only decision making; it's also referring to the competent authorities when breaches occurs, because like obviously this association, environmental association, have a specific role when it comes to the breach of environmental regulations. And I think this is also the same with
That's exactly the same with corruption. Most of our recent cases started after an association, which is Amnesty International or whatever, filed a complaint, and the prosecution or the prosecutor had to start the inquiries, the investigation. Let I come back later on this, because there are specificities in the French system. So maybe let me tell you this right now. You have two kinds of complaints. You have a complaint which is a simple complaint that does not compel the prosecution to take action, and you have a complaint which is the plainte avec constitution de partie civile, which has to be filed before the president of the investigation judge. And if you do that as an association or a company or as a simple person, you can compel the prosecutor to open the investigation. So yes, they play a very strong role in the French system.
And I think your question was also related to the fact that coal mining, if I understand correctly, in Russia is also done by small companies, so we don't usually in France it's more we don't have coal anymore, but energy companies are like big corporations usually. And of course, it's harder for small or medium businesses to report on their obligations. But when even if you're a small or medium companies, and this is where like compliance and corporate social responsibility are the distinction is necessary. When you're a small company, you also, even if you don't have to under the law to report and do this kind of vigilance plan or that, it's very important for your reputation. So actually, small companies with activities like activities in environmental or coal or sensitive topics have to do it on their own initiative, just to avoid any reputational risk. But there is no, the constraints on these companies are not the same. Do we answer your question?
Да, спасибо. И один маленький дополняющий вопрос. Прислушивается ли правительство и государство к деятельности экологических активистов? Ну, самый популярный, соответственно, Greenpeace, либо других экологических активистов, которые своими акциями не в юридическом поле, а в общественном сообщают о тех или иных экологических нарушениях?
Yes. So we can say that our current environmental minister is an activist because he has his own foundation and he has working. Nicolas Hulot, he worked as an activist for years and accepted to enter the government of Emmanuel Macron, and so. Is very dedicated to the environment and of course to listen to associations, because he was also a member of the civil society and he knows how important it is to in this field to have association doing what they're doing, and so yes, the government the government listen to environmental associations also because they have the duty to associate environmental associations in the lawmaking process. This is the Risk Convention I mentioned earlier, And in French law, all major, and as in the US, all major, I don't know if it's the case in Russia, but all major development projects and all that must associate the stakeholders, associations, but individuals who may be impacted by the development project and all that. So they're associated from the beginning to the end, and they still have the courts if they disagree. So yes, I think environment, in France, the environment is, the environmental policy is far from perfect, but associations are really associated all along the decision-making process. So I think it's really positive, and this is a very the field of the environment is one of the most advanced in this when it comes to lawmaking and the association of the participation of all stakeholders.